And I get killed all over YouTube because people say I'm so mean. I mean, it's are we supposed to coddle everybody? Are we supposed to coddle you for just 10 drinks when you know you're on a freaking probation?
All right, folks, buckle up because this courtroom showdown is absolutely wild. We've got a defendant on probation for a DWI who decided that the rules simply didn't apply to her. How bad did it get? We're talking 10 drinks at a birthday party while she's supposed to be in a treatment program, and blowing nearly double the legal limit on a breathalyzer. The judge? He's had enough of the excuses, and he is about to deliver one of the most brutally honest reality checks we've ever seen on this channel. This is a case about accountability, second chances, and what happens when someone pushes a no-nonsense judge to his absolute limit. Trust me, you do not want to miss how this one unfolds.
I have Carol Ramirez.
Where is she?
She's right there, Judge.
Come up, Miss Ramirez.
The state wants to do a 6-month extension for her to finish her treatment. She's had a couple of positives. I had a chat with her.
I'm not down with that. I'm not down with you just continuing to drink. You're not supposed to. That's the first damn elementary thing of this program is you don't drink, and you're continuing to do it. It's not going to happen. I mean, do we need to put her into an inpatient treatment program?
They're recommending IOP and SOP.
The cost of an inpatient, because with DWI PTI.
Oh, I'll revoke her bond. It'll be free.
Hopefully we don't do that, Judge. Can you give her a chance to do the IOP SOP? I had a chat with her.
You want to keep in this thing? I'm going to put you in inpatient treatment. You're going to go right now. There goes your life. 6 months minimum. And if you're good, 6 months. Right. If you're good, I'm sorry, 6 months. Otherwise, it's a year and a half in custody. No means no. Doesn't mean I've got a party. I've got Jesus telling me to do it. No. How many positives? Let's not get ahead of ourselves.
So she completed the DWI education, effective decision making, and victim impact. On March 12th, she admitted to consuming alcohol. And then on June 20th, she provided a blow of 1.53.
0.153, that's nearly double the legal limit. That's gotta be, that's
When the probation officer,
that's like eight drinks.
she said she had 10 drinks and she was celebrating her sister's birthday.
No.
Okay, let's pause right here because this is absolutely critical. She blew a 0.153. That's nearly double the legal limit of 0.08. And her excuse? She was celebrating her sister's birthday with 10 drinks. 10, while on probation for a DWI. Let me break this down for you. When you're in a diversion program, the number one rule is simple. Do not consume alcohol. Period. No exceptions. Not for birthdays, not for holidays, not for anything. This isn't just a minor slip-up. Folks, this is a complete disregard for the conditions that are keeping her out of prison. The judge is absolutely right to be furious here.
There's got to be some kind of sanction. No.
Judge, can we do, instead of putting her in inpatient, can we maybe take her in for the weekend and then let her out and go her with her
I'm okay with
treatment?
that. Yeah. And then at that point, I'm going to put an ankle monitor on her.
Can you let her come in? Did you drive here?
Yes.
Can we, her car is gonna get towed. Getting her
And
car out
I
of
care
impound.
because
Well, so I know this is not the court's concern. I'm saying my concern for her is that if you take her in right now, her car is gonna go to impound. Her family can take it out because they need a power of attorney. She's gonna come out with over $1,000 in fees only to get her car out. But she will come back.
we continue to cater to everybody. And I get killed all over YouTube because people say I'm so mean. I mean, are we supposed to coddle everybody? Are we supposed to coddle you for just 10 drinks when you know you're on a freaking probation? Shameful. You ought to be ashamed.
And there it is. The judge just said what so many of us are thinking. Are we supposed to cuddle everybody? This is exactly why this judge is so respected. He's not afraid to call it like it is. The defense attorney is trying to negotiate about the car being towed, about impound fees, about convenience. And the judge is like, hold up, this woman had 10 drinks while on probation for drunk driving. Let's be real here. When you're given a gift of staying out of prison through a diversion program, you don't get to party like the rules don't apply to you. That's not how accountability works. What do you think? Is the judge being too harsh? Or is this exactly what she needed to hear?
That tells me that you either have a problem or you just don't give a shice about us. That's what that tells me, you know? And yet you still want a dismissal of this case. It doesn't work like that, you know?
I don't know if it makes a difference, but I've had her on bond for quite some time. And she's been on the program, she did her classes. If you give her a chance to come back, and if she doesn't do it, then I won't even have anything to stand on or come before you to say anything. And I don't think she will either. And being before you, I think she understands, right?
Yes.
Right? That if she does not take advantage of this opportunity, then that will be the end of that program for her.
Now, this is where it gets interesting. The defense attorney is doing her job, advocating hard for her client. She's pointing out that Carol has been on bond, she's completed her classes, and she's asking for one more chance. And honestly, that's what defense attorneys are supposed to do. But here's the thing the judge is weighing. Carol didn't just slip up once. She admitted to drinking in March and then blew nearly double the legal limit in June. That's a pattern, not a mistake. The judge has to decide, is this someone who made an error in judgment, or is this someone who simply doesn't respect the program? That's the million-dollar question right there.
Yeah. We're going to have Pavel. So, you know, I'll tell you the only way is 3 days as a condition, and she'll have to turn, do you have a license? Can you run her license, please? She'll have to do the 3 days, and then as soon as she gets out, immediately she'll get a SCRAM.
Okay.
She'll have to pay for it because I can't pay for it. You know,
Well, since it's a contract with the state, I guess you could drive with the SCRAM.
I want to make sure first she has a license. Okay. Do you have insurance?
Yes, I do.
Okay. Hey, Pavel.
Yes.
I need you to please amend the contract. And I don't know how, but so this is Miss Ramirez.
Okay.
She's had quite a number of blows, positive.
Okay.
We're amending to do 3 days as a condition. And then she's
PTI.
on the PTI.
Okay.
Well, and then the other issue is that if you want to put her on a SCRAM, then we need to amend the contract to reflect SCRAM, but allowing her to drive. Because normally the way that it works on your template contract is if she gets a SCRAM, then automatically there's a non-driving affidavit.
Right. No.
So
We'll
that-
keep everything as is, but I want to make sure that she's not at all times, she's not consuming. Whereas here, all she has to do is blow, right? So we'll do the extension, but that's the conditions, right? So 3 days is a condition to begin, I guess, within the next couple days.
So
And
how
then
do you?
upon release, she has to get the SCRAM, and then she has to do IOP and SOP.
Okay, let me break down what's happening here, because there's a lot of legal terminology flying around. The judge is ordering 3 days in custody as a sanction. That's jail time, folks. Then, upon release, she has to wear a SCRAM bracelet. For those who don't know, SCRAM stands for Secure Continuous Remote Alcohol Monitor. It's an ankle bracelet that detects alcohol through your sweat 24/7. You literally cannot drink without it knowing. She also has to complete IOP, which is Intensive Outpatient Program, and SOP, a standard outpatient program. The judge is essentially saying, I'm giving you one more chance, but you're going to be monitored every single second. This is her last lifeline.
How do we do that? The sheriff won't take her in. So if she shows up, if it's a civil contract, we can do in the contract 3 days as a condition, but if she shows at the jail and says, the sheriffs won't take her in because there's nothing in the.
Melissa?
Can she do it, Judge, she's a full-time student, can she do it over the weekend, like go in next Friday and come out on Sunday so she doesn't miss school?
What days are you school? See, I mean, we continue to cater to people. That's all we do here. We cater. It's like,
The only way she can do the 3 days is if you revoke the block. So whenever she wants to go in, she has to come in, and then we have to revoke it, and then you have to bond reinstate it whenever you want her to get out.
I just want to make sure that from a practical perspective, we can get it done. So what
if you ever test positive again, you're going to lose 6 months to about a year and a half of your life. Do you understand me? So if it'll be the best damn party, best damn beer, best damn drink, best damn smoke, whatever it is, you ever test positive again, I'm telling you, inpatient you go. Because it really tells me that you have a problem and you're incapable of stopping on your own. So we'll do it for you. That's it.
Did you hear that? The best damn party, best damn beer, best damn drink. If any of that happens again, she's looking at 6 months to a year and a half behind bars. No more negotiations. No more chances. The judge made it crystal clear. One more positive test, and he's sending her to inpatient treatment, whether she likes it or not. And honestly, that's not the judge being mean. That's the judge potentially saving her life. DWI isn't a joke. People die because of drunk drivers. The fact that she's still getting an opportunity to stay in this program is incredibly generous. She better not waste it.
Okay, so I guess let's reset the case between now and what's your school schedule like?
I have class Mondays and Wednesdays, in the morning and the afternoon.
What about Thursdays?
Thursdays, no class.
What about Fridays?
No class.
Okay, so let's start on Thursday then. Okay, because that way she'll get a bed. Otherwise, she'll be sleeping on the floor. It's too many people going in on Fridays. They sleep on the floor, as opposed to if you go in on a Tuesday through Thursday, you get a bed. So we'll have you come back here on Thursday. Can you amend it between now and then?
I've never done that. I'll see if that's even possible.
I don't think-
Anything can happen,
Well,
man.
Judge, if
Really?
Judge, if you revoke her bond and she goes into custody, let's say we do Thursday, well, probably better Friday, so we can have her on the docket on Friday and Monday.
Okay,
And then
I'll
we come back
reinstate
on
on Monday.
Monday, you reinstate her, we don't have to amend anything.
all right, good.
Just so we can kind of,
I understand. Okay,
that's, okay.
Yep. Okay.
And then we'll just amend, if you want to do the SCRAM, then they'll just amend that. portion.
I mean, if they tell me that they can't do that, then I'm not going forward. I'm not going to do it because it's not fair that she's out drinking 10 beers or whatever 10 drinks in one night. And it's a slap to the face and everybody else that actually complies with this thing. No way. I'm not going to do it. So, okay, we'll see you on Friday. So.
And that, ladies and gentlemen, is how this case wraps up. Caro Ramirez, a defendant on probation for DWI, violated the most fundamental rule of her diversion program, not once, but twice, by consuming alcohol, including blowing a 0.153 on a breathalyzer after admitting to 10 drinks at a birthday party. The judge, despite his frustration with what he called coddling defendants, ultimately granted her one final chance. The conditions? 3 days in jail, a SCRAM ankle monitor upon release, and completion of both intensive outpatient and standard outpatient programs. One more violation, and she's facing 6 months to a year and a half in custody. This case is a perfect example of the balance courts try to strike between accountability and rehabilitation. The judge wasn't being cruel, he was being real. And sometimes that harsh reality check is exactly what someone needs to turn their life around. Now I want to hear from you. Do you think the judge was too lenient, too harsh, or did he get it just right? Drop your thoughts in the comments below. And if you found this case as eye-opening as we did, smash that like button, share this video with someone who needs to see it, and make sure you subscribe to the channel so you never miss another jaw-dropping courtroom breakdown. Hit that notification bell because we've got more wild cases coming your way. Until next time, stay out of trouble